Hi, this is Jose Noriega, and I'm with
Robert Guest.
and Robert. You are my boss, but we work together at Guest and Gray. Is that correct?
I don't like to say boss. I like to say
Well,
collaborators in legal jurisprudence studies.
or spiritual advisor, correct?
I've never
Um,
said that. That's a label you can use.
but we're going to talk to you today about community supervision. Essentially, what is community supervision? Who sets the conditions of community supervision? Can they be modified? Revocations of community supervision, which can be one of two things: either a motion to adjudicate or a motion to revoke. Whether your client's entitled to bond for a revocation or adjudication. Um, a little bit about hearings and what standard of evidence is used, and a couple other little rules in there. Are you entitled to discovery for revocations, and a couple little tips and tricks that we've learned throughout time just handling revocations. So if you hear me talk about probation instead of community supervision, it's just because it's easier to say. And Robert, anything else that you think we want to cover on this?
I really prefer the term deferred adjudication. I wish that was a real word. I really do.
It does roll off the tongue a little easier.
It sounds cool.
It sounds like some type of drink, right? So moving in, community supervision is what the Texas Code of Criminal Procedure calls essentially probation, right? There are two different types of community supervision. Deferred adjudication, which is where the judge will actually find that there's sufficient evidence to find you guilty or find your client guilty, but he won't actually find your client guilty. He'll withhold the finding. And then there's what they call straight probation, which I think we all kind of know is, maybe after a jury verdict, for instance, and the jury sentences your client to 5 years, but then recommends community supervision. And so the judge gets to set kind of the term of probation for those 5 years. So it would be, 5 years probated for 10 years, for instance, or if you can agree to straight probation. So maybe on a state jail felony, it's 2 years probated for 2 years, right? And so it would end up being 2 years of straight probation, which means that your client has been convicted.
Well, I think with deferred and straight, the big difference for people who aren't familiar with it, deferred is not just that you're not convicted, it's that you're open for the whole range of punishment. And so like you take deferred on a second degree, like you can get any sentence on a motion to adjudicate, motion to revoke between 2 to 20, right? Whereas if you got a second degree straight probation, A, it can't be over 10-year sentence or you can't be on probation. But B, the longest sentence is in there. And so let's say you get 10 for 10, right? 10 years in TDC, probated for 10 years, right? Well, there's the maximum sentence built in. You can't get more than 10 years. And then you can still go in there on an MTR on straight probation and kind of work down the numbers. Like you got 10 for 10, but you say, well, we'll do 4 TDC, right? And so it can still be negotiated, but the maximum isn't the range of punishment maximum. It's what, the years you took are. So you're probating the jail sentence at that point, the prison sentence at that point. And I think that's important for people because I don't know why we started calling it straight probation or what's, the straight part about it, but it's post-conviction probation. So the issue of are you convicted or not has been settled. You are. So for felonies, you're a felon, if you take regular
you've
straight
got
probation.
all the disabilities of being convicted with that, right?
Yeah. And so deferred, though, that's still an open issue. And so you can get like a motion to adjudicate and mess up your probation, but stay on, deferred and never get convicted. They can like never adjudicate you. And I know like sometimes when you're negotiating a settlement on a motion to adjudicate, like you'll stay on probation, but they're like, well, we're going to adjudicate him, right? They're going to want you to be convicted of the felony. Like that's the loss, which
always makes no sense to me. It just seems like a pure vindictive type of situation, right? So
well,
if they do where it's deferred and then all of a sudden we're going to do straight probation, it's like, oh, basically you just want him to be able to say he's a convicted felon.
Well, yeah, we're not going to prison, so
let's limit his job opportunities. Okay, that seems fair, right?
Well,
I mean, I guess it is better than going to prison for 4 or 5 or whatever the number is, but
well, that's why people take it though, because if they're saying, hey, we'll let you on probation, but you have to be adjudicated, you can stay on paper and not go to prison. Your client, that's going to be a lot of pressure to say yes to that. because what's your other option, right? To have the hearing with no determined sentence and just try to figure out what the judge is going to do. And so,
yeah, absolutely. So, but moving on, there are certain offenses that you cannot get probation for, murder, capital murder. I know you used to be able to get probation for murder. They're listed in what used to be called 3G offenses. Now they're 42A.054. And you'll have to look at the code because certain ones you can still get, or certain offenses you can still get it directly from a jury, but you can't get it from a judge. And there are certain offenses that the judge has to give you probation for, or your client probation for. So a lot of the state jail felony kind of drug cases is the main ones that I think of. The hard part about that, and as we'll move on, is that the judge kind of sets the conditions for those. And so, you can get up to 6 months, for instance, as a condition on state jail, possession of the cocaine less than a gram, even if you lost a trial. And so I know Robert and I have both had experiences where, you've got a mandatory community supervision client and, prosecutors offering you straight probation. It's like, well, heck, we got nothing to lose at this point.
Why not go for it?
Yeah. Even if my client's got a 2% shot at trial and drugs are found on his lap as police are walking up and he makes a 30-minute confession while he was under Miranda, and, might as well try to do, some type of jury nullification or something along those lines to make him work to get that conviction, because ultimately a judge has to give him probation in that situation. And Robert, I know you've had plenty of circumstances like that as well, right?
Well, if you're looking at why do people take offers that maybe you want to go to trial on? So you got a client, he's got a state jail dope case, and they offer him straight probation. And so why would he want to do it? And because we've both taken court appointments, and you'll get people who are like, I just don't want to come back to court. If I take this, can I quit showing up here? And they're like, well, yeah, but this is like our worst day at trial. But clients don't always make decisions based on, what's the best logistical move for them on the chessboard. They're like, well, can I quit coming here? Can I quit coming to see you at this courthouse? Or I'm just tired of being on bond. I want to get this over with. And so they'll do stuff like that. And to us as a lawyer, you're going, dude, this is like your guaranteed probation outcome. If you just let me try this thing, I'll try to find something in here, we can try it. But a lot of clients, they don't want to sit through trial. They don't want to sit there for a couple of days. The whole process stresses them out. And so as a lawyer, I think when those kind of things happen, you got to admonish them like, hey, you know that you're like probation mandatory, right, at the end of this, and make sure they understand that. But there's reasons people do things that maybe, they kind of give up on a procedural advantage where, hey, you get I'm not going to say a free shot at trial, because like Jose said, you could get probation, but the judge could go, but you're going to do 6 months as a condition, or you're going to go to SafeP or something. Nobody wants that. So there's some risk there, but it's still, you don't see it. At least the counties we practice in, you don't see a ton of state jail dope trials because they usually offer you deferred on it, which is like, you're like, okay, people take deferred, or they offer you they'll reduce it to a misdemeanor. But it's something where you want to make sure the client understands though, just what the sentencing options are, because it's more on state jail drug cases. It's more than just explaining the range of punishment. It's explaining the mandatory probation provisions.
Yeah, absolutely. And so going to some of those conditions that you talked about and I spoke about, as far as, jail as a condition, right? So in most felony cases, you can get up to 6 months in jail as a condition. So, and as far as deciding who the conditions of probation, it's kind of an odd situation, right? So you come to a plea agreement with the prosecutor and you say, hey, I don't want to, we're not going to take anger management, right? We agree on that. And then all of a sudden, your client gets to probation and probation says, well, for this type of offense, we're absolutely going to put you on BIP or batter's intervention or anger management or whatever the case may be.
I've had clients plea and get a modification that day. They go into intake and probation oh yeah, the judge didn't order this. Well, you're going to agree to this modification, right? And they just shove a piece of paper in front of them. Yeah, right. Or they do an intake interview and they go, you need all these services and classes and you negotiated those. You feel like this is the bargain. And
so that's one of the hardest parts, is that they they do that, and 42A.051 and 42A.052 kind of allow them to do that. And so the probation officer can literally, give your client a modification, no counsel there, nothing like that. Just, okay, we're gonna add this as a condition, and okay, it's now a condition, right?
Well, and what
can come back and say, you know what, like, I thought about that plea agreement, and I followed the plea agreement. I did everything, but now I can change the conditions if I want to, and I want to throw them in jail for 30 days, right?
Well, and think about not just the legal procedure of it, but just the optics to the client, right? Like you're working with your client, you're telling them, hey, I got you a deal and you can do probation, but it's going to be without all those classes you didn't want to do because you work a lot, or,
Yeah.
And then all of a sudden
where you don't have to do community service and you're going to be, donating cans or whatever.
And then he gets to probation and they go, will you sign this modification, sir? And he goes, and all of a sudden he's doing all the things you told him he didn't have to do because you worked it out with the prosecutor. And one thing Jose's not mentioning that I think most people know who've done a bunch of these, though, is like once the case is pled, like, probation they can just put a modification in front of him. And they don't, usually call the defense lawyer going, hey, we're going to do this modification. And usually the prosecutor's not even in the loop on it, right? It's just your guy in a room with his PO and you hear about it later. And so there's some cases, more serious offenses, or especially for things like polygraphs. If I think that's an issue, I'm going to go, listen here, defendant, your PO asked for a polygraph and we got to talk, right? We got to be ready for that because you still have some rights to like not incriminate yourself and you got to know what to say. But for stuff like misdemeanors, you don't always think they're going to do something like that. Usually they don't, but your client is still dealing with the state, dealing with agents of the county and the state government, right? And they're doing that without the advice of counsel because we're not there anymore. And so when you bargain for conditions, and I've done this too, where we said, hey, we're not going to do X on probation. My client understands the other conditions, but we're not doing this one condition, right? Like the GPS or something. And then it gets ordered, like, especially early on, if it's not ordered like as a result of a violation, I will say, hey, we need to go see the judge and go, I bargained for this, judge. Like, this is part of my deal that we relied on. I use that contract language because we talk about plea bargains as a contract.
And so,
yeah.
I mean, you think that you've agreed on something, and all of a sudden it's like, oh no, we're going to change it. Sorry. And we don't even know that it's been changed until after the fact. And our client's sitting there saying, if they happen to return at some point, they're sitting there saying, well, oh yeah, I was ordered to do this and I had to do this and this and this. And
we're not even notified, right? It's not like a filing we get through like the e-file services going, here you go,
Yeah.
They don't usually even tell us.
Yeah. It's always kind of crazy, but there are certain required conditions for certain offenses, like a DWI, they'll make your client take a victim impact panel or a drug offender education course in some situations. And so generally speaking, for felony cases, your client will do what they call a PSI or PSR, depending in federal court. And they'll kind of determine the risk and needs, if you will, of your client. Basically, it's very odd situation because, although it's not admissible into court, they're still talking to a probation officer and detailing the offense and what happens if it's kind of an open plea situation, right? Where you want to spit your version out to the judge and the judge only, and not, give the state a heads up on what the way you feel it happened. So you have to be very careful with those. And, I know I've told a lot of my probationers or, my clients before, hey, if they ask you anything about the offense, we're not going to answer it. Just a heads up, we're going to save that and waive and show that to the judge and the judge only.
One thing I like
to going through it all completely.
One thing I like to do on PSIs is try to get my client like the blank form. And that way I can go, this is kind of what they're filling out on you, and kind of go over the areas I think could be a problem, because a lot of them, most of them don't have any idea what to expect, right? And they don't know the questions. Can be like, tell me every time you've thought about using drugs ever, and tell me all about this offense. And you're right. If you're doing an open plea, and you want to not just share everything about it with the state yet, like there's reasons to say things or not say things, and you've got to be careful too, because I mean, none of this is privileged. It's all going to be out there, and your client's telling the state that they did all these things. And it's something where you need to help them understand what these questions are, what they can and can't answer. And, and I always think if they're not going to answer, it's best to say that's on the advice of counsel, because, on the one hand, you want to look like you're being transparent, with their PO, but at the same time, you don't want your client to get in more trouble because you set them down to get this PSI done. So it's a situation where I think you need to give them as much information as you can about the process, and areas are going to be a challenge. You've got to have a strategy going into it.
Yeah. And so again, jail can be a condition of probation. Does it happen all the time, unfortunately? And you'll see that as far as, oh, hey, we're going to you failed the drug test. We're going to do a little modification and sanction you, quote unquote, for 3 days or 4 days or whatever it is. And a lot of times if it comes down to a revocation of that probation, your client won't even get credit for that back time. I know it's a tough situation to try to tell a client that, but hey, I know you spent 6 months in jail, but that was a condition of probation and you're not even getting back time credit for this. And sometimes you'll find a prosecutor that believes differently. And I love those prosecutors because, they'll give them their back time credit for that, but oftentimes, they won't. And so it's not necessarily a fun thing. But let's say that your client is revoked on probation, or a motion to adjudicate is put forward. You're not entitled to bond for your client on a straight probation case. You are entitled to a reasonable bond for a motion to adjudicate. You can do it by filing either a writ or a motion to set reasonable bond. I know Robert and I see this fairly often where, for any revocation coming out of a court, it'll say no bond.
No bond, even on misdemeanors. Yeah, misdemeanor deferreds.
For misdemeanors. And so it's kind of crazy. I always I'd prefer to file a writ in those situations because generally speaking, they're appealable. And so you're kind of giving the judge a heads up, like, I'm entitled to this bond. And if you don't give me a bond, I'm going to, seek a mandamus or something along those lines.
Well, what are they doing though? Like what's the play here? I think that it's, if it's deferred and they know they're entitled to bond and they still put a no bond, because the judges, they should know this stuff, right? That I think it's just a way to kind of get your client in jail for a couple of weeks while you try to, litigate your way through this as a defense lawyer. But what does it do? It gets him on the jail chain like 2 weeks later with all this back time. So on a misdemeanor, maybe he just takes time served, he's done, right? Or he'll be so desperate to get out that the state has all this leverage now to play him. I really think it sets your client up for failure, and unable to negotiate really, because he's stuck in jail, he can't get out. And so your options are to convince the judge who just set the no bond, right, to grant your client a bond, or to make it reasonable, or to hear this soon. But it really puts the state in a position where they could just get whatever they want on these adjudication jail chains and revocation jail chains when your client's stuck in there because they just want to get out, man. And so it puts a lot of pressure on your client. And if your county does that, if you have a judge that does that, you need to know ahead of time and try to talk to local defense lawyers on how to maneuver through that.
Yeah, and I think that's one of the biggest things is find out what that county's kind of customs are, right? As far as the revocation or setting a bond, do they like to go through the prosecutor, and maybe the judge just does a no bond until, the prosecutor says, oh, judge, yeah, he's actually entitled to a bond. Let's do, it's weird, but I mean, by all means, if you can't get a bond, file a writ, file a motion to set reasonable bond and get that going. They can add bond conditions, just a heads up, which is even more burdensome for your client. I've got one right now that, already had an in-home device, and as a condition of bond, they want GPS and Scram. So, I mean, that's 700 plus bucks a month that my client's having to dish out because, it's kind of, they just want to do that for bond. And so just be aware that they can do that. Also, the Code of Criminal Procedure does allow for you to have a hearing within 20 days. Generally speaking, the remedy is to get a PR bond if the state's not ready within that 20 days. I only like to use that in certain situations, right? If it's a complex case where the state is going to have problems proving it, some type of, the only allegation is going to be, a Ponzi scheme, right? I mean, that's a tough situation for the state to prove within 20 days versus, oh, well, he's behind on just fees. Okay, maybe not as tough for the state to prove because they can just call one witness and be done with it.
Well, new offense is out of county. Like if your client's in Dallas and the allegation is he picked up a new charge in Harris County, right, down in Houston, then you go, well, let's have our 20-day hearing and just let's see who shows up to say we committed a new offense, because that can be really hard to prove. But if it's something that you can just get from the PO going, yeah, he didn't pay his money and he failed his UA,
And that's where you need to be very careful when you're requesting it, because all it takes is one allegation to be found true, and your client's subject to revocation.
Are we at that part of the slideshow yet?
Here we are.
Well, I try to read most of the appeals that come out of Dallas, and if you're going to appeal a revocation and the guy had let's say a 10, and you have a legal objection to the evidence, that it's insufficient or it shouldn't have been allowed in court, if the state has one thing, like he didn't do his community service, right? That's all they need. And so it's a matter of, you have to win every allegation if you're going to try to go up on appeal and go, they can't revoke us. And so, because what you see a lot is, you'll have an objection to some kind of evidence or that they didn't prove one of the allegations. And if you take it up on appeal, the court will go, well, he had one, like he didn't report in June. So he's open to the whole range of punishment now and deferred, And so it's something that you see where the defense lawyers put up the arguments and objecting, and the state just has to fall back on, we got one of these by the standard here as a preponderance. We got one of these by 51%, or 50.1%. And so we don't care about your objections. We can ignore that because the state has this. And it's something you should read so often on appeal bit. And you understand the impetus because, you're fighting for your client, but it's not hard, for the state to uphold revocation on appeal. It's easy for them. And so I guess
as long as they have some evidence, some testimony, the odds are the Court of Appeals is going to affirm the decision, and trust us, they'll find a way to affirm it.
Yeah, and it comes in a thing where the PO's in there and says, you didn't pay in June, right? Or you didn't report in June, right? Well, they can go, well, that's enough. That's 50.1%. So you're going to actually attack their evidence to try to win on a preponderance, which is so difficult. And it's in Jose's got the slide here, but it talks about, you're not guilty beyond a reasonable doubt of violating your condition, right? It's just, is it true or not true by a preponderance? And that's one thing you got to explain to clients, especially when they have a new charge as an allegation, because they think, well, they got to come and prove me guilty, right? That I did this new thing. I'm like, no way, man. They just got to show there's a more than 50% chance that you did it. And it's so different. And most people aren't set to think of it that way. They've got that's the one standard in criminal law they know, right? Beyond a reasonable doubt. You got to go, not a probation, man.
Well, so that's exactly. I mean, in the Court of Appeals, they always say it's revocations are just administrative in nature. And so, yes, the rules of evidence apply and the Constitution applies, but, they find a lot of leeway in their thinking because they are administrative, quote unquote, in nature. I don't think there's anything administrative about taking someone's freedom, but the Court of Appeals disagrees with me. As far as, the bifurcated type of system that we have, it really depends on best practices and looking at the county itself, right? Some counties I've seen where they do bifurcated revocation hearings on every case. Other counties I've seen it where they, it's kind of, they do the entire thing, and judge says true or not true. I find the allegations true or not true. I grant the state's motion to revoke, and I sentence your client up to 20 years. So you have to be kind of careful when you're presenting evidence and finding out whether they do that bifurcated system or not. And so because if they don't do a bifurcated system, you're going to want to throw some mitigation evidence in there, and bring up to your client's employer, or mother, or whoever can testify, and they're trying their butts off, right?
It's so hard to mix those arguments though, because you're in a career, they probably have a lot of usually have more trials and you have like actual revocation hearings, especially depending on what county you're in. But you don't think, hey, besides fighting the evidence, I got to put on that my client deserves a break on sentencing at the same time, because you feel like putting on punishment evidence, you're doing what? You're like conceding that we should be punished, like implicit in punishment evidence is there's going to be punishment, right? But instead, if your judge wants it that way, that you're going to go, well, we're going to put in that, we should get a good sentence, while we're saying we shouldn't get any sentence. And that, I don't know, it's hard for me to juggle mentally sometimes, but Jose's talking about, well, if ask your judge if he's going to treat it as a bifurcated hearing or set it separately for punishment, or give you a chance to at least separate the arguments. But if you can't, you just got to do it. So, I mean, like every good trial needs a punishment strategy, every good revocation needs a punishment strategy.
Well, and at these hearings, you'll have the probation officer testify, and it may not even be the same probation officer, and you object, okay, these are all the probation records, hearsay, right to confront X, Y, and Z, right? 99.9% of the time, oh, these are non-testimonial. Well, what other purpose could they serve, right? I mean, it's not so that the probation officer gets a raise tomorrow. It's literally tracking for the purpose of what,
because we don't,
they mess up.
Like, why don't we let police reports in, right, as like business records or whatever? Because police reports are made, in anticipation of litigation, right? Like that's part of the function. And so we don't let in police reports during criminal trials, right? But, probation records, I mean, are definitely made in anticipation of litigation. But, we let in chronos, like that's what happens. And POs come up and testify to them, right? And so it's a situation where, if you treat it just like a trial, well, it's not, and so you still need to have your objections ready. But at the same time, if you're going to have a kind of an objection-based strategy that they don't have enough here to prove it, I mean, you really got to think about if you have any evidence of trying to go on offense on some of these things, or like, if we didn't pay something, for example, like in money situations, you actually you have to prove it,
Yeah.
It's not enough for you just to defeat the state's burden of proof. You got to go in there going, hey man, here's my light bill, and here's how much money I made, and here's my child support, and I didn't have any money left over to pay your fines or whatever. And so it's the burdens are so different than a criminal trial, and you need to be familiar with them and just what kind of evidence is going to persuade your judge. Because I mean, obviously, I don't think we've said it, but I mean, there's no jury on these, right? It's the judge. And the other thing I always tell clients too is I ask them like what their goals are going into these things, because a lot of times they have to go right back to that PO who's in there testifying, this guy should go to prison, and you got to say, I've had clients tell me, for example, I don't even want to go back on probation, right? I'm done. Just get me out of this thing. And at the same time, you're attacking their PO, and they got to go back in and work with that person. If you're successful, they got to go back in and try to work with that person. And so we haven't really talked about the PO defendant relationship.
And one of the things that I've found very helpful, and I know you have as well, Robert, is calling the actual probation officer ahead of time and being like, hey, what's the deal here? And, sometimes I've been able to find out stuff that's not in the chronos, as far as, hey, look, I've told him at least 15 times, like he's got to at least pay one payment, right? Or, hey, I told him he needs to start on his community service, and I've been working with him for the last 3 months on trying to find a place that can do it. We found one last week, and it's just not in the chronos at all. And so a lot of times that does help, as far as, just kind of understanding what is happening a little bit more, because, when you get these chronologicals from the probation office, or from the DA's office. It's just kind of these, you know, they're long and tedious and advised defendant on X or Y or Z. And it doesn't really explain, okay, well, you met with the guy for an hour and you only wrote 2 sentences. Like, let's figure out what's been happening.
And part of your job, it seems to me, you know, as a defense lawyer, you're kind of like the mediator, because your client may not have great interpersonal communication skills, or the PO might just be frustrated because they're going, I've told your guy to do this X, you know, and he's never done it. And you go to your client, you're like, you're going to do this thing tomorrow, dude. You're going to go in and pick up the trash, or like make the payment, or take the UA, whatever it is. Like, and so if you can, and I tell people, like, if you go through kind of the list of things you're deficient on and try to see, what can I knock out? Maybe I can win this thing back over and convince the PO that my client, you know, can work on probation. Because I mean, what do I say? Discretion can be the better part of valor. If you can fix that relationship and convince the PO that he can be back on probation, you know, because a lot of times what a prosecutor will do is to kind of rely on, well, does probation, what do they think? Can they work with him? You know, and I've had prosecutors say probation doesn't want him, right? They don't want your guy anymore. And so you've got to do this advocacy job that, hey, probation, I'm sorry that my guy could, you know, did all these allegations for violations, but he really wants to do better. And here's what we're going to do now. I mean, one thing we haven't talked about yet is like your guy's way behind on his fines. And you say what? Hey, if we can get X sentence that we want, like, would you consider that if we made, you know, X lump sum payment towards, especially stuff like what? Like restitution, right? Because, you know, your prosecutor has a victim coordinator somewhere and and they want that restitution. And so,
you know, I never have my client pay money unless we're going to get something out of that. Right. I mean, I'll have them do the community service. I'll have them, you know, take their classes, do whatever they didn't do throughout probation, except for the paying money part.
Well, let's qualify that though. So, I mean, if he gets put on probation, you're going to go pay the money. But if he's being revoked for a big deficit on, let's say, restitution, you know, and he goes, hey, I can pay this off right now. You go, well, hold on. Don't just do it. Let me see if I could negotiate it first, right? Because once you pay it, you know, you haven't got anything.
Yeah, exactly. You know, so, and I know we've both had situations where, you know, all of a sudden client is able to sell his vehicle, get enough restitution, we can actually not only win the revocation and get the revocation off, but maybe make his probation non-reporting or something along those lines, where it's even a better outcome than he went into it.
Yeah, or we've taken court appointments. You have a client in jail, they have a big balance, and like, you know, relative, you know, fiance says, hey, I can get the money together, right? And so you're trying to coordinate with this third party to like get to the, you know, DA's office or wherever to make the payment, you know, so your client can get the better deal. Because a lot of times if you can solve some of the financial parts of a case, and more so in like misdemeanors and stuff, then you can get a better result than if you can, you know, go in and like, you know, go guns blazing at a hearing. Because people want to see those fines paid off, you know, and that can be leveraged in some counties. It's very local specific. Some places don't care, some places do. But I find that restitution usually carries with it some weight in negotiations. And if you can make a payment or pay it all off, you might get a second chance. Whereas if you have a case that doesn't have any restitution, right, like your DWI or something, you don't have that move to make. I mean, what are you going to do if your guy's failing his deep lung device, his interlock, right? You can't go, well, we'll pay the fine faster. It doesn't usually carry the same kind of negotiating leverage.
Absolutely. So what could happen at a revocation hearing? Number one, most judges will accept plea agreements. There are certain situations. The main time I see them is kind of with specialty courts where, you know, the case gets transferred to, you know, a certain court, and all of a sudden that judge wants to handle the revocation. And, you know, that's kind of a little scarier for your client. I'd probably tell my client, hey, you know, get your belongings ready.
And there's like a relationship there, right? Specialty courts we haven't gone over because they're so different. You know, because they're showing up all the time with like this group of people they work with, you know, like they'll have the counts. Yeah.
I presented an entire CLE on specialty courts in Dallas a year ago. And so there's just a lot of different specialty courts. Just know that they're out there, know to look for them. because odds are there's some type of specialty court that could be applicable to your client. Whether it's DWI, offender court, veterans court. I know that's a big one, and it's got some really good results.
That can
drug court.
Like if you have a guy who's on probation and he's doing bad and he's eligible for a specialty court, right? You can offer to go, well, what if we put him in this other program, right? And if you have a client who's in a specialty court and he's getting revoked, that is way different than a guy who's on like regular probation getting revoked, because specialty courts have their own culture and they go in, they usually meet more often. They usually meet in big groups. And there's like a little council beforehand with like the judge and the PO and the specialty court coordinator and like the prosecutor and maybe like a defense lawyer. And they kind of round table talk about all the defendants. And so you're not just going into a thing where it's just the allegations. There's been a group of people working with your client in a specialty court. And if they've collectively decided that revocation is the best path forward, that is a really difficult situation to work your way through. I mean, because it's not something where it's kind of a disinterested, the judge just now found out there's revocation, is just reading the allegations. If they're in specialty court and the judge is real interested, they know your client, man. They've been working with him, and they already probably know what he's going to say, right, to the allegations. And so if you have a specialty court revocation, you need to learn as much as you can about the specialty court and what they already think about your client, because some arguments you might want to make may not work because they've been talking to your client about these problems. Some meet weekly, right? And so they could have been talking to your client every week about why he hasn't done community service. And you need to know what he's been telling them, right? And what they've been saying to him and who's frustrated with him. So.
Absolutely. So, you absolutely need to know what's been going on. And that's when, speaking with the probation officer, speaking with the specialty court probation officer, you can kind of get a better gist of the situation. But moving on to, what could actually happen at a revocation, obviously on a deferred, the entire punishment range is open for whatever offense they're on probation for. For straight probation, obviously the maximum amount of probated years is the maximum amount of time that your client could get. So if he's on probation for Berg-Hab, which is a 2-20, and it was 10/10, so the most your client could get is 10 years. There are certain situations where the judge can, extend or modify or continue on probation, and it happens fairly often. But we've seen it a lot of times on like kind of drug cases where client keeps getting dirty UAs. Well, odds are that your judge is probably going to modify and possibly send to some type of drug treatment, right? I think the best practice would be start getting your client in that drug treatment ahead of time and maybe get some clean UAs while he's out on bond. If he's not on bond, then I know a lot of jails offer NA meetings and things like that'll try to help your client in hopes that he doesn't have to go to SafeP, just because I haven't seen a single client really want to go to SafeP. And so there's just a lot of options that the judge can do. There are certain situations where there's nothing that can be done. It's either prison or release from probation. And a lot of those times it's if your client has already expired from probation. So, they file a revocation the day before probation ends. They don't find your client for a year and a half. Well, at that point, there's not much that they can really do except for, revocation or discharge from probation. Again, sanctions are absolutely available, and they use them. It's kind of looks like the same slide. It's a little different as far as modifying conditions of community supervision. Again, a lot of times you can go to the state and see if they'll modify or agree to a modification of, let's say that they can't be around X person, right? Well, X person's their wife, and they live in, or they did live in the same house. Well, hey, let's agree to modify that condition. I know it's generally a condition for, assault, family violence, but we're going to modify that so that he can live at home. Some judges, again, want to be the sole person that decides all the conditions of probation. realistically, you can file a motion to modify conditions of probation. The judge always has authority to modify the conditions. So, let's say that, he wasn't allowed around any children. Well, you can file a motion and say, Judge, we think that he should be allowed around X, Y, and Z because, treatment provider says that he's not a threat to these people. It's not even closely related to the crime that he was charged with. And so, just best practice would be to call your prosecutor, talk to your prosecutor, see if they'll get to agree, see if the probation officer would be on board, and then file a motion. I know, Robert, I think we've done that. I mean, it seems like we're almost doing it on a weekly basis nowadays because, probation conditions keep changing for some of our clients that, it's nothing that we had agreed to.
And it's what we talked about this earlier too, though. You gotta, if especially on serious felonies where they can have conditions that people really, 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 really don't want, you've got to have your client ready that if they're going to try to modify or talk about a modification, you know what to do. And so, especially if those are things you've negotiated, I mean, that can change so fast. I mean, I've had them like literally clients call me like, hey, we just pled, and like 3 hours later, they're done with their first probation intake and they're going, they want me to sign this thing that says I'm going to do all this other stuff. You got to have them ready for that. And it's another thing where you got to know your county because it can be different, but it's when it happens, it looks bad. They go, well, you promised me, or you told me we had a deal. I mean, your client's going to be, bewildered that, that this happened so quickly, and you've got to be able to work them through it. So.
Well, I know in Kaufman, for instance, they actually give you, there's a form that says, these are all the conditions we could possibly give you. And I mean, it's incredible. And it says limited or not limited to. And so, you've got states like jail, safety, Wilmer, all these different conditions that they could possibly give someone. And I mean, you need to go over that with your client in great detail because, I wouldn't necessarily see it off of one positive UA, but if there's been a couple positive UAs, your client could very well end up in SafeP, which is, 6 months of inpatient treatment, 3 months of waiting for a bed.
Calling it inpatient treatment is very kind. I would say it's inpatient prison.
Yes, because they are free to leave, correct? And so, you really need to be careful, and your client needs to kind of understand that, and it's tough to, you're scaring the crap out of your client when you're telling them these things. In all honesty, hey, I know that you're only on probation for a state jail felony, but I'm just giving you a heads up. If the judge feels like it at any time, he can give you 6 months as a condition. I know that's the minimum for this offense, but.
And one thing that happens too is when they give you all these conditions is it puts you in a position where you're telling your client, there's some conditions and I kind of matter more than others because they put, you may not leave, Kaufman County will say this, you can't leave the county. And your client's like, I work in Dallas, and you go, well, what they mean is your PO has to give you permission to travel for work. And if you leave the state or try to go further on vacation, you have to let them know. But they put in stuff like that they go, I'm already going to violate this, And then they have conditions that I don't think people really care about. Just like no gambling, because if your client buys a lottery ticket at the gas station, no one's going to know. But I've literally, in my entire career, never seen a single revocation based on somebody gambling or playing a game of chance, because that's on there. You can't go play a game of chance, and they have, you can't hang around people of disreputable character. And people go, what does that mean? And I've literally never seen a revocation for that either.
I'm waiting for my first phone call on that I won the lottery, and now they're revoking my probation.
What do I do now?
Yeah,
And these are just kind of, and I wonder, these are some antiquated, gambling is bad, but it just kind of makes it look silly when there's stuff in there that isn't going to be really looked at. But you have to tell your client, well, if this does happen, you technically could get in trouble, but I've never seen it happen. And I just think if they're not going to take it seriously, we just need to drop these things. But the counties like to list everything under the sun on there. We'll put, no gambling, no being at, places that are bad. I tell people, like, don't be like at a, at a brothel or something, because you don't know what they
be
mean.
around. Don't do vicious habits or something along those lines.
Like, what
Is
is
usually in
that?
there. It's like, well, I mean, is eating McDonald's, is that a vicious habit?
Vicious habits.
I love McDonald's.
Well, and you
But
want to give people clarity, but we have these rules that we don't use and haven't been updated. And so you read into the clients, are like, what the heck does this mean? But I think the ones I usually see pushback on are when they go, you can't leave certain counties or contiguous counties. And they go, I got to work, or my kids live in another place. I got to pick them up. And you're right off the bat trying to get with the PO going, hey, we need travel permits, permission to go here and there. And most of the time they're usually like, we don't care. That's fine. Just have them tell us. And so you're saying the rules say do not do X. And you're immediately going, well, your PO says you can do X, which, kind of, it just sets it up where, and this is the dynamic where your PO for a defendant has so much power over them. And I would tell clients, hey, you need to really win this relationship. You need them to like you, man. And so like, you can have a case where your client's like, this charge is bogus. I didn't do it, whatever. The state sucks. I don't want to take this. And then they reluctantly take some deal, right? And you got to say, don't bring that energy in with your probation officer, man. They're not the bad guy, right? They're not the person who's doing this to you. And if you do that and you alienate them, they can really, really make it hard for you to succeed.
Well, and I think one of the things I always tell my clients is, hey, look, probation's meant to fail in Texas, right? I mean, it just, with the fees and the community service and, classes and everything that they add, I genuinely think it's meant to fail. But one of the things I tell my clients is, hey, look, if your probation officer says, don't come to this meeting, this month, you're meeting this month with me, come next month instead, send them an email.
Yes.
It's not very difficult. Send them an email just saying, hey, just to verify, I'm not coming to this meeting this month per your instructions. I'll see you on the next whatever meeting date. Same thing with, a lot of times on community supervision, they'll say, you must perform 8 hours per month community service until you reach your, 120 hours. I can't tell you how many times we've seen where my probation officer wanted me to take my classes first, and then I could worry about my community service later. And, that's great. If they said that, verify it, send an email saying, hey, just a heads up, we talked about that I'm going to take my classes here in the next couple weeks. And then, once I'm done with all my classes, I can start my community service.
What Jose is saying is, and this is something else you tell people they're going to change the rules right off the bat, is you'll sign up for conditions of probation, right? And they'll say, you're going to pay this fine in like X days, right? And you're going to pay these court costs within like a month or something, right? And your client goes to probation, and what's the first thing they do? They put them like a prorated schedule for all their payments. And so they're making monthly payments, which is what their PO has ordered. And if they do that, they're literally violating the agreement they just signed in court. And so the court will say, here's your payment schedule X. They go to probation goes, forget that thing you signed and swore in front of the judge you're going to do. We're doing this other payment thing. And it's so fluid like that, where the probation can just change, not even just like the conditions, to get them modified, but like how they're enforced or how you comply with them. And it can put your client in a lot of jeopardy, because what happens if there's no evidence of what the agreement was? They're going to look at the rules and go, well, the rule said this, you didn't do it. Like if your PO says don't report in June, we're going to be out of town or at a seminar, right? And then you don't, well, you better have something that's showing you don't have to report, because if it comes back on that and it's just, you're in a position of what? The only person who's going to be able to say it is your client. And we don't always want our clients to testify. So Jose's got a great point that if your client's going to not do exactly what the rules say, and because he was told that by his PO, his probation officer, he needs to document that in some way that maybe he'll get in his chronos, or at least he'll have to rely on later.
Yeah. And even if they don't respond to it, it at least shows where your client's state of mind is, right? And shows, hey, look, I at least interpreted this conversation this way. I sent an email verifying that I interpreted it this way. They never responded to that email. I have, if I'm the judge sitting there, I'm, hey, why didn't you at least tell them, like, no, I still wanted to see you this week. I was talking about, going to your class this week and you misinterpreted that. And so I think that it really does help as far as, show your client's mindset at the time that, although he may have violated the conditions, he wasn't doing it intentionally and, just ignoring the judge's conditions. Because let's face it, during a revocation, a judge is going to sit there and say, well, these are my conditions of probation, right?
Yeah.
And you just decided not to follow my conditions. And it's just not, well, Judge, wait, hold on. It's not that I didn't want to follow your conditions. I was under the impression that it was this, and I've got this evidence that shows that, which also does seem like a burden shifting type of situation. But let's be honest, there's a burden shift.
Well, and when you tell them you've got to strictly comply with these, right? And then the PO goes, do something completely different, right? It makes it look like, it looks like a mini modification when they just go, here's how we're going to enforce the rules, even though this isn't literally what they say. Because we don't, as defense lawyers, we don't like that kind of uncertainty, right? Because there's so much risk to our client. And we would rather know what we're supposed to do and how it's supposed to be done. But it can literally change from the time you sign it in court, especially with like payment schedules, like, or how you're going to report. That can all change so fast. And
it changes before they leave the courthouse. In Kaufman, they go from the courtroom to the district clerk to get copies, then to the probation office.
The intake, right?
And they take their photo and fill out 1 million questions, and then they go immediately to the payment, the annex building, to make payment arrangements, right? Even though it says, this fine and everything must be paid within X amount of time, or immediately, or, but they just do that. So, but moving on, let's talk about the good side of things. When we get phone calls for early terminations, and, there are certain offenses, just a heads up, that you cannot get early termination for. However, it kind of intertwines with, you may not be able to get early termination for it, but you can absolutely modify the conditions so that maybe your client at least feels like they're getting early terminated. Let's say that you've got a DWI client, which is generally not allowed to get early termination for, and they've done all their conditions. They paid all their fines, everything up front. They only have, they've been on for 6 months out of a year probation. Well, you can't terminate their probation, but you may be able to do where the rest of their probation is non-reporting, right? So as long as they just stay out of trouble for those 6 months, the state isn't going to revoke them. But in all practices, or realistically, the judge is supposed to review everyone at 1/3 of the sentence or at 2 years, whichever is lower of the two. I've never received notification of that before. I think maybe one time I did. But I know, Robert, have you ever gotten notification that a judge is reviewing a client for early termination on their own?
And I think, if I'm right about this, this law came in like 4 or 6 years ago. And I think after then there's some impetus to go, we should have these review dockets. Mm-hmm. But then, I don't know, I just don't see the momentum for that anymore. And it's very court specific. And so you can have a case where the guy should have already had an independent review by the judge. This hasn't happened. And what I tell people when they call me, and I think Jose's the same on this, is if you want to try to get off early and you're eligible to get terminated early from probation, I like to say do half the time. It's a little bit more than 1/3, but I think it kind of really shows if you can comply for this long, then doing the rest half, you're going to be fine, right? You did the first half, so it kind of shows a pattern that you can do this, you've got it. And that usually gives them time to get everything done. And so you've done a little more than kind of the statutory minimum there to get a review, and you're kind of asking for one yourself. And so when you file the motion, you want to make sure you prepare your own order for an early termination, because you can ask for judicial clemency is what they call it, where you put in language that says, hey, the judge grants early termination and withdraws the plea, releases your client from all penalties and disabilities resulting therefrom. And it looks good. It sounds good. It's like your client didn't plea. It dismisses the charge. The only real weakness with it is you can't get an expunction based on it, or
non-disclosure.
And so, so it doesn't help for record sealing. If you're already eligible for like a non-disclosure with a deferred, then like you can still get one, but it doesn't like help you in any way for your record sealing. And I don't like the interpretation of that. I really think it should get you more. But what happens is your client has that piece of paper now to show, hey man, like this thing is gone. It's like it never happened. It's like I shouldn't have any penalties from it. And I still try to do it, and I try to put it in all my petitions for early termination and orders. But
and I think that you know, a lot of times waiting till 50% of the time, I've had prosecutors actually tell me like, oh yeah, they're eligible for it. I'll agree to the motion. And I'm like, okay, I don't think that's the law, but
it's,
that works out perfectly if you agree to it. A lot of times they'll oh, well, I can't agree to it, but I'll defer to the court.
I won't object to it, right? I won't say too much.
Yeah, and that's why I have in there contact the court coordinator to figure out what the judge likes in the motion. A lot of times they'll want, something saying, hey, a statement whether the probation officer is okay with it or not okay with it, or they agree to it or don't agree to it, what the state says and whether they're agreed to it.
Is it the kind of charge a judge is going to want a live hearing for, right? Or is it going to be one they're just going to want to go, just give me kind of a status update, give me a letter from probation telling me he's done everything.
Yeah,
which is something I usually put that in my motion that like we've paid all of this and done all of that. I mean, I try to get that up front, but it's, there's some cases where the judge may not. He may want to have like if you have a case with like a victim on it or something, right? And they get to come to court, like you're gonna need to have a hearing on it.
And I always want something in the motion, kind of giving the reason why we want off probation early, right? Hey, judge, he's having to travel for work and do all these things, and every time he has to travel, he has to call his probation officer, see if he can get a hold of them first and foremost, and get permission to go to Louisiana because he's on a sales call out there. And so I think showing the judge a reason why he wants off probation and not just because I don't want to be on paper tends to help quite a bit.
And I don't know if this is a great argument, but I always like to say, if he would have messed up probation, judge, as defendant, we would be punishing him, right? But we have done great. And so I think there should be some kind of bonus on this, because it can't just be like, bad things are punished. It should also be that good behavior on probation is rewarded, and you'll see some prosecutors go, well, judge, he signed up for X years. He should do all of them on this thing. And that's what I like to go, well, if we would have messed up right now, he wouldn't be saying we get to do our X years of probation. He'd be saying we're going to prison, right? Since we did good. And my rebuttal to that too is always, well, judge, we signed up knowing we'd be eligible for early termination. And the state knew too, when they signed up for it, that they're eligible for this. And it's a situation where if you have a client who is eligible, you want to find out the local practice, you want to see what kind of evidence a judge is going to want, and you're going to see kind of how your prosecutor is going to react to it. And I know everybody wants off probation, but you'll see some judges are more agreeable to it than others. And for certain offenses, especially, we probably know what they are. Like judges are not going to want to let people go on them early, but it's something that if you can do it and you can put something in there and have a compelling story, I think judges like to be proud of people who've turned their life around or like made a big change, and they want to have something where someone does better, because so often in criminal law, we only hear about people when they do terrible or they fail or they make mistakes, right? And so I like to give that to them. And I tell my clients on all kinds of cases, give me something to say about what you're doing with the time you have or what you've been doing recently that can people be proud of you, that you'd be proud to tell people. And so if you're not doing that with your clients, maybe implement that in your practice too.
Yeah, absolutely. So wrapping up some practical tips on handling revocations. Have your client do as many of the conditions. If they're on bond, have them do as many of the conditions as possible during the pendency of the case. I always tell clients, hey, look, I don't care if it's mowing your neighbor's yard. Go do that. Help get some of those conditions back for us, right? The more people I can get to say that you're a good person, the better off we are. The more conditions I'm able to sit there and say, hey, judge, he realized he messed up. But we're doing X, Y, and Z to fix that. And we're actually trying to go above and beyond. tends to look good in front of a judge. Only request a hearing, in my opinion, within the 20-day hearing for highly complex matters, or where the state's gonna have problems proving their case, or obviously if your client's wanting his right to a hearing, then hey, you got to do it. This is one thing that we didn't talk about before, but it's by far one, we're in Kaufman and we see some prosecutors that were there filing motions to revoke. I mean, we had one filed 2 weeks afterwards, and I had a client get arrested 3 days after he was put on probation. So there's case law out there. You can file a motion to quash, file a motion for new trial if it's within 30 days. You don't necessarily want it to get granted because you want him to still be on probation, but it'll extend to the start time of the probation. So what that basically means is that the conditions of probation are not in effect until that motion for new trial is denied as an operation of law, or the judge actually denies it.
Okay, so I think you said file a motion to quash, but you mean like quash the revocation. You mean file a motion to new trial, which then will quash the revocation, right?
Exactly, yes. And so, just in best practices, what you want to do is, on my client that got arrested 3 days after he got on probation, I filed a motion for new trial, within a couple of days of that. And I mean, they were never able to file a revocation on him, just because his probation start date is technically when that motion for new trial is denied as an operation of law, or the judge actually denies it, which I believe is 75 days out. So you always keep that in mind. You're not filing an appeal. You're not filing a notice of appeal because you've waived appeal, but you haven't filed motion for new trial. And I know, Robert, if you want to talk about one of the hearings where the prosecutor just kind of,
I'll be fast,
incredibly confused.
I think we're bumping up on an hour, but
we are. We
had one of these, and my client got revoked super fast. I wasn't really thrilled to hear this, but it was a serious case. I mean, we're looking at prison time, and it was our best move to file a motion for new trial because we've been revoked within 30 days. And the whole time of the hearing, the prosecutor's going, "Judge, he waived appeal. He waived appeal." And the judge he knew his stuff. He's like, "Well, they didn't file a notice of appeal. They filed a motion for new trial." And so, yeah, we were doing it for the procedural effect of what it had, which was, we wanted to not have probation start so we couldn't be revoked. We wanted to basically reboot probation and start at a new time. And so until that new trial was overruled or operation of law, expired, they couldn't revoke us during then. And so it was to my client's benefit. I mean, if you have clients who are going to get revoked that fast, it's not a great situation for their future performance. But I really think in this case, I think he's been found on probation actually since then. And so it got up to a terrible start. But it was maybe been prosecutor specific with this case, that he was just looking to bust us fast, and he was a little over eager to revoke us. But we found a way out of it. And so if you get a revocation within 30 days of your guy pleading guilty, file a motion for new trial. And we're going to call that the Jose Noriega special, because he taught it to me, and it's a great move.
No, but it does work very well. So if you have any questions or anything like that, we hope you enjoyed the presentation. Our contact information, robert@guestandgray.com, Jose Noriega, jose@guestandgray.com. Our office number is 972-564-4644. Again, thank you all very much for watching, and this is available for an hour of Texas CLE.